Calls the case. People versus Daniel Gates.
I ask the court to please set this for exam. Your Honor, discovery is late at this time.
Ms. Hughes has to.
Thank you, Your Honor. I downloaded a spreadsheet of defendant's jail calls and sent them to defense counsel, and then I downloaded the relevant jails and sent them to him so we get an opportunity to listen to them. I am requesting that the defendant's jail phone privileges be revoked. Since his arraignment, the defendant has contacted the victim 13. He actually had another defendant who's present today, we'll hear about him shortly, call the victim in this case and ask her for a different phone number. She provided that different phone number to other defendants that she otherwise doesn't know. And when I searched that different phone number in the jail call system, the only person to have ever called that number is Mr. Gates after that. So I'm requesting that his phone privileges be revoked. And I provided the jail calls to the defense.
I have nothing to add.
Defendant's bond will continue, however, defendant's phone privileges are hereby ordered revoked. Your name, sir?
Cody Lee Jolly.
All right. And we have your competency report back. Have you had an opportunity to review that, sir?
I have.
Pardon?
I have.
All right. Is there any other additional evidence you want to give the court?
Not at this time.
None from the people, Your Honor. We would stipulate to the report authored by Graham Parker dated May 7th, 2024, and ask that the court make its finding based on the.
Based upon a review of that report and the only evidence before the court would find that the defendant is competent to stand trial and that defendant understands the nature and the objects of the proceedings against him and can rationally assist in his defense. And so the defendant is deemed competent. I'd ask the people to prepare an order if you could.
Yes, sir.
In this instance. Mr. Jolly, do you still wish to continue to represent yourself, sir, or do you wish to have the assistance of an attorney?
Continue to represent.
And sir, I do also have to advise you that you are before the court on 2 charges. It's 2 charges. 2 charges of criminal sexual conduct in the 4th degree. You understand that, sir?
I do understand.
And that these are alleged to have occurred on January 27, 2024. You understand that?
I do understand.
And the court also does have to advise you that these are high court misdemeanors. They are punishable by up to 2 years incarceration and or $500 fine plus court costs, mandatory HIV and STD testing, and DNA would be taken upon your arrest and should have been taken. You understand that, sir?
I do understand.
All right. So, sir, I will formally ask you, do you still wish to proceed without counsel?
Yes, I do.
All right. What do you wish the court to now set this for, sir?
The last that I was aware of was the preliminary exam that we were doing. I'm trying to move forward as quick as possible, so I'd ask you if that's where we start, that's okay. If we move
You
forward,
wish to set for a preliminary examination?
if that's the furthest along I can get, then yes.
Well, that's the next step.
Okay, then yes. That's
All right. So you want to have a preliminary examination in this matter, or you want to proceed to circuit court? There are a number of options that you would have.
okay. Yeah, if we can proceed right to the circuit court, that would be okay.
Okay. All right. But you understand that there would not be a hearing, the preliminary examination, which the court would attempt to make a finding or would make a finding as to whether or not crimes were committed and you committed them. That if you were to proceed directly to circuit court, that hearing would not take place. You understand that?
Trial. Yes, I understand.
Mr. Jolly.
Yes, I do
Mr.
understand.
Jolly. Mr. Jolly.
Yes, sir.
You've been before me, I don't know how many times, right? Are you sure you don't want somebody to just help you make these decisions and to assist you as an attorney in this case?
Again, I choose to represent myself. I was aware of the help and was thankful for the help the other day. If you recommend that I talk with somebody as I leave here.
Well, I'm not going to recommend you do anything. I'm a little bit concerned because when I ask you questions, I don't think you know what you're doing. I don't think you know what you're doing procedurally. And that causes me a bit of a concern. You want to get to, as I told you the last time you were here, you want to get to a certain point. You're not sure how
Let's
to
go back
get
to the
there.
preliminary exam. We can
You want a preliminary examination?
that'll work. Yes, I will.
All right. If you want a preliminary examination, you intend to represent yourself.
Yes.
Is that correct, sir?
Correct.
Do you have all of the discoveries, sir?
I filed for it. I'm gonna have to refile now that I'm competent, but I don't, not when I'm in my possession because I was incarcerated.
All the discovery has not been provided. You don't have it.
It was emailed to me, but I'm incarcerated now, so I don't have it now.
So it was emailed to you when you were out?
Correct.
If the people could try to make sure that whatever discovery is, it be provided to the jail so that they can get it to this defendant.
I can print another copy of the report,
Okay.
not today, the printer in our office is broken, but there was a media notice, that was body cam that was given to him in court at one of the last dates.
Okay.
That was on a DVD.
You remember that, sir?
I do remember the disc. Yeah, I didn't. Yeah.
Okay.
So he has the disc.
He has the disc. He just
Another copy of
the paper report, and we'll get that to you. Okay. Would the people have their witnesses available the 4th, or you need more time? All right. Preliminary examination in person will be set June 11th, 2024, 9 a.m. That's before me. Bond will continue. Okay. Versus Bruce Jones. Preliminary examination will be set in person June 4th, 2024, 9 a.m. That is before Judge Perry. Bond will continue.
Need to address is.
Oh.
Other tampering from the last date. I'll go with the phone privileges first. At the last hearing, I believe it was Ms. Rosso requested that his phone privileges be revoked. The defendant requested a hearing on that. After Your Honor then revoked his phone privileges. When the defendant went back to the jail that very same day after leaving your courtroom at 10:50 a.m., he got on the phone and called the victim and advised the victim that you had revoked his phone privileges, and then instructed the victim to download an app called Text Now. And he said, if they're going to take my phone privileges, I'm going to still call you, but another way. And that was after Your Honor revoked his phone privileges. Since then, as far as I can see, his phone privileges have been revoked. But he did manage to get to the phone and make that call after the last hearing before today. And then we still have the tether tampering, which is where community corrections received the notice that he was cutting his tether. They reached out to him. They asked him to take a picture of his tether to show them that he wasn't cutting it. He refused to do that, and then they see based on his location services that he was then leaving the area that he was in. He was arrested. The tether has a clear cut mark on it, and he told community corrections that his dog was chewing on it. So at this point, I'm requesting that Your Honor continue to deny his bond, which was denied after the tether tampering situation, and I'm asking that Your Honor continue the revocation of phone privileges.
Any response?
What was that court date for Judge Perry, real quick? I need to know.
The 4th.
Thank you, Your Honor. Your Honor, I'm going to leave that to the court. My client wants to focus more on the preliminary exam and deal with the case at hand, Judge.
He's waiving the hearing on the phone issue.
Yes, Your Honor.
All right. And the court will order that his phone privileges are revoked as they previously had. And so this bond will continue in all other aspects as revoked. Court calls case People versus Victor Hayes.
Thanks, Your Honor. This is going to be a waiver and a bond violation.
Yeah, it may not be a waiver. He's blowing numbers. Why?
Oh, Your Honor, this was
Mr. Allen.
an honest mistake on behalf of Mr. Hayes. He had company over on May 8th. He blew a .033 on his SoberLink. He's been on a SoberLink since November. And when he was having dinner, the company that he had with him, his friends and family, they had non-alcoholic wine. And Mr. Hayes was unaware that non-alcoholic wine actually can contain some to little bits of alcohol. So Mr. Hayes just wants this
You're
court.
going to tell me you got to a .03 on non-alcoholic wine? Is that, no, I mean, if that's what you're telling me, go ahead. I just want to make sure I'm hearing what you're telling me.
Your Honor, I spoke with Mr. Hayes about this, and the only explanation to this violation was what I just stated for the non-alcoholic wine at dinner. And he wants this court to know that this was an honest mistake. He's understands that he needs to do his due diligence and make sure that he's not around any alcohol whatsoever. And he would just like you to know that, he's sincerely apologetic, and he's asking this court if it would allow him just to give him a chance to remain out of custody, continue to test while he's doing this.
Then tell me the truth.
Judge Simpson, can I address the court, please?
If you want.
I've been testing for a while, and this all started in 2022 when I took it upon myself to Sacred Heart. And I'm trying to get some closure to this. And I had company over, and we had what I assumed was a non-alcoholic wine.
Hold on. You assumed it to be, or it was?
I assumed it to be. So I take.
Well, hold it. There's a big difference. Huge difference.
Well, only what I can say is that she said, "Oh, this is non-alcoholic, so I'm not supposed to drink." She said, "Well, this is not non-alcohol." So when I got the call from Mr. Wells and he said that I have blue numbers, I was shocked. It really didn't taste like alcohol, but I take full responsibility. I apologize to the courts. I'm trying to do my best to comply with what the courts want me to do. I've been 000 for quite some time.
When you test.
Yes, I see Mr. Allen is behind me, so I know what that means. So I mean, I got a lot of responsibility, and I apologize to the courts. I really do, and this will never happen again.
Well, somebody needs to tell me the truth about what it was, because if one counsel got up here and said you were having non-alcoholic wine, but it has some alcohol in it, that's different than it was non-alcoholic wine, or I thought it was, or I assumed it was.
I understand. Well, when I spoke with Mr. Simpson, Mr. Wells, Judge Simpson, he said, "Don't you know non-alcoholic wine contains some alcohol?" And I never knew that. So it's an
Not to get
honest
you to
mine.
these, how much of this wine did you have?
I had a couple glasses, and I mean, it didn't taste like alcohol, but I mean, I had a little buzz, but I didn't realize it was going to cause me Mr. Allen to be standing behind me. And
You got, don't you worry about what Mr. Allen's doing. You got,
I'm sorry, Judge.
story doesn't add up.
I understand.
Because it's not off it. Why is he getting buzzed off of non-alcoholic wine? I mean, you know what you're doing at some point.
Yes.
Well, if he wants to waive, he'll do it next week.
Understood, Your Honor.
But at this point, defendant's bond is revoked, defendant's remanded.
It's your honor.
I get nervous when you're behind me too.